Chamber of Commerce and Industry, we welcome you to an exciting session, a special session curated by the Legal Committee of the Bengal Chamber of Commerce and Industry. Without further ado, I would now request the Chairman of the Legal Committee of the Bengal Chamber, Shri Deep Narayan Mitra, to deliver the formal welcome address.
Good evening, ladies and gentlemen. On behalf of the Bengal Chamber of Commerce and Industry, I and oldest Chamber of Commerce in the East of Wales, and my colleagues in the Legal Committee, it is my pleasure and privilege to welcome the Honorable Justice Moushumi Bhattacharya and you all to this special session with my law. Justice Bhattacharya has a very bright academic career in Georgia House. Then with Jagatpur University and later with the Calcutta University Law School. She had her LLM at the University of Cambridge. She was enrolled as an advocate and practiced very successfully in the Honorable High Court at Calcutta, other High Courts in India, other various statutory authorities in India, and of course for the Supreme Court of India. She was elevated to the bench of the Calcutta High Court on 21st September 2017. Today, she is one of our pride judges. Today, we are eager to hear from Justice Bhattacharya about the latest change under the Commercial Courts Act, which is comparatively a new act, the scope of which is being widened by the recent tribunal reform, rationalization and conditions of service ordinance 2021. As to how far has the Commercial Courts Act been successful in achieving its objectives. I believe that our delegates present here today would be very much benefited by the delivery of Justice Bhattacharya. Over to Justice Bhattacharya.
Thank you, Mr. Mitra, and a very good evening to everybody who is present today. I hope the sound quality is good for all of you because some of the words of Mr. Mitra, kind words, were lost on me because the sound is not very clear. So I hope it's fine.
We can hear you clearly.
It is fine?
Yes.
Thank you. It's good that I'm addressing a group of what I would describe as literally the river basin from which rivulets, productive ones, reach the commercial courts, at least in the Calcutta High Court. And I am sure that my audience today is well versed and very familiar with the Commercial Courts Act and at least with the ordinary original side jurisdiction of the Calcutta High Court. The topic I thought which would serve best for my target audience this evening is latest trends under the Commercial Courts Act and whether the Act has been successful in achieving its objectives. I would first just like to give you a quick structure as how I would want to divide my talk. To break the monotony and to give you some relief, I will be sharing my thoughts on the Commercial Courts Act and the recent trends. And I will supplement it towards the end with some slides, a parade of slides, a kind of a slides handout, if you wish, just to give you a quick reckoner as to the what is the Commercial Courts Act, what are the trends, what are the key features of it, and whether it's been a success. So the slides will really sum up my talk and will also give you a kind of some variety, add some variety to the talk. And that's number one. Number two is with regard to the content of my talk, of what I propose, at least in the next half an hour, is the familiarizing of the judiciary as well as the practitioners, academics, with the Commercial Courts Act 2015. It is really a very new act with provisions which I can only speak for myself, which I am getting to know every day, as it were, with on learning on the job, because the appendix, the amendments are so varied and are so detailed, each of them, that it's really I'm getting to know of it. The second feature is the fast tracking aspect of it. How has the Commercial Courts Act fast tracked the entire trial and adjudication procedure as was envisaged under the CPC, under the Civil Procedure Code, and whether it's changed? How has the Commercial Court really changed all that? I will supplement it with some notes, reference to a few cases. I will not really make it monotonous or tedious by referring to a whole lot of cases, but just the more catchy part of it, the more remarkable part of it, and end my talk before the slides with some thoughts on the Commercial Courts Act, the constitution of the commercial court benches, at least in the Calcutta High Court, and some very personal, a personal take of the act from my part. So let me first go on straight away to the content of it. When we talk about the Commercial Courts Act 2015 to a person who's not really familiar with the provisions of it, the first, Shukarna, can we come to the slides later? I will ask for the slides. I will tell you when to really, thank you. So when we talk about the Commercial Courts Act, the catchphrases which kind of jump out from the objects and reasons of the act is investor friendly, high value, complex questions of fact. So the object of the Commercial Courts Act was essentially to give a facelift, if I can use that term, to the Indian judiciary, to the Indian court system, and to attract investors by projecting India to be an extremely investor-friendly destination where investors' money would be protected, would not be wasted, would not be lost in the labyrinth and delay of court processes, and investors would still be hopeful that there is a chance that we will see our money at the end of the day, whether it's a commercial suit, whether it is an arbitration proceeding, whether it is enforcement of an arbitration, whatever it may be. If we lose, we lose. But if we win, there is a fair amount of possibility that we will be in a position to retrieve that money and get that decision, get justice in as quick a time as is possible. So this was the object with which the act was, I think it was the 353rd Law Commission report, which thought that, we better do something, pull up our socks, and that they were kind of egged on by what is popularly known as the Ease of Doing Business Index of the World Bank, which ranks the countries in accordance with how easy it is for investors to go to that country, invest their money, and to do business, not only for outside investors, but for investors within that country, and feel comfortable, feel hopeful and encouraged. It's a good judicial system that we are in, which will look ahead to give us some sort of a relief, adjudicatory relief in as short a time as possible. So that was the vision of the framers behind the when they enacted and contemplated the Commercial Courts Act. So the objectives, quickly in a very quick glance, would be to expand the scope of the commercial courts in India to, that's A. B, to contribute towards improving India's ranking on the Ease of Doing Business Index released by the World Bank, in line with the global economic environment. C, speedy, convenient, and efficient dispute resolution. Next, growth of a healthy, robust foreign direct investment, public-private partnership, which calls for legislative measures for speedy settlement of commercial disputes. Next, to create a positive image amongst investors about a strong and a responsive Indian legal system. Next would be a streamlined procedure for quick resolution of high-stakes disputes of a commercial nature and with contemplating strict timelines. And last and not the least, discovery and procedure for grant of summary judgments. So these three in a nutshell, I mean, that's really the way I look at it, is the objective of the Commercial Courts Act. Now, just to give you a quick idea of the global context, India is really not the first country to think on these lines. In UK, for example, the Commercial Courts Act was established in 1895 and was recognized as a division of the High Court in 1970. A commercial court committee in the UK monitors adaptation of procedures to the changing the commercial environment in the community. In USA, particularly in New York, the commercial division was established in 1995. And a remarkable feature actually in the state of New York is the state-of-the-art technology, including flat screen monitors in jury boxes and at the table of the arguing counsel, electronic blackboards, real-time court reporting, electronic projectors, and all kinds of other infrastructural innovations, computer docking stations for counsel, arguing counsel, video capability, etc., which was really popularized and now has become a system in the US and particularly New York. In France, there are, as of now, about 134 commercial courts with jurisdictions over disputes between merchants, bankers, etc., and controversies involving commercial corporations and also bankruptcy proceedings. And I would say a unique feature in France is that judges are elected for a term of 2 to 4 years by an electoral college of current and former judges of commercial courts, and you'll be surprised, delegates from traders' bodies. So that's really something new. And in Scotland, commercial courts actually deal with a wide range of cases, which include transactions and disputes, I mean, everything under the sun, which is of a commercial nature, including disputes of building contracts, partnership agreements, business property, so on and so forth. So this is really a quick kind of a global survey to show that India followed the global trends in contemplating a legislation of this kind. So we quickly go to the jurisdiction aspect of it. Now, Section 3 of the Commercial Courts Act defines the constitution of commercial courts, and a notification, it actually started with a much higher value. But there's a notification which we had of 20th March 2020 of the Judicial Department of the Government of West Bengal, fixing the pecuniary jurisdiction of the commercial courts, and which says, actually starts from the bottoms up. It says that provides for that in Siliguri, Asansol, Alipur and Rajarhat, it would not be less than 30 lakhs within the territorial jurisdiction of the City Civil Court, it would not be less than 3 lakhs and not more than 30 lakhs. So 3 to 30 lakhs, that's the bracket. The High Court would have concurrent pecuniary jurisdiction with the City Civil Court, that is from 10 lakhs to 1 crore. So City Civil Court would be from 10 lakhs to 1 crore, and the concurrent jurisdiction would be with the High Court, that's 10 lakh to 1 crore, and High Court would be unlimited. So anything above 1 crore would be that of the High Court. So this is as far as the pecuniary jurisdiction is concerned. And the more important part is, which every discussion would have to kind of touch upon, is what exactly is a commercial dispute. When we say that, when we talk about commercial courts, we have to go to the Commercial Courts Act and see what exactly is a commercial dispute. Now, under section 2C, that's the definition, 21C actually, 21C, a Commercial Courts Act defines commercial dispute as a dispute arising out of any kind of transactions listed under subclauses CI to CXXII, which is 22, including but not limited to transactions in relation to merchants, bankers, financiers, and traders. We had the Supreme Court giving its consideration to this aspect as to what exactly is a commercial dispute in Ambalal Sarabhai, which is of versus KS Infraspace, which is of 2020, 15 SCC, that's the citation, 15 SCC 585. And the Supreme Court, I think it was the decision of Justice Bhanumati, if I'm not mistaken. Justice Bhanumati dwelt on the provisions of the Commercial Courts Act in the backdrop of what would be a commercial dispute. And the Supreme Court actually cautioned against giving a liberal interpretation to strict timelines and to the strictness of some of the provisions. For example, where there is a shall, it cannot be read as may, etc. Because the Supreme Court felt that if we stretch the timelines and if we give a liberal interpretation to these strict provisions, then we would be defeating the very object of the Commercial Courts Act. Ambalal Sarabhai, apart from Ambalal Sarabhai, there have been not too many decisions on that point, but I remember a decision, Harji Engineering versus Hindustan Steelworks, where I had the opportunity of looking into this issue, and whether 21C, merchants, bankers, financiers, and traders, these are the 4 divisions, whether a commercial court should really restrict commercial disputes to commercial transactions between these 4 categories. And of course, my view was that yes, because commercial courts, you have to really strictly adhere to what the Act says. And merchants, bankers, traders, financiers, those terms were defined. And I've forgotten what I finally held, but the crux of the matter was that transactions must have a commercial flavor. As opposed to, for example, a hand loan. Somebody lends me money and the loan is in a piece of paper, and I rush to a commercial court for whatever relief I want. Or actually the person who's given me money rushes to the commercial court to get back the money, would not really make it a commercial dispute subject to other conditions of 21C being present, because a hand loan is really an informal transaction without any recording or any evidence of showing that the person who has got the money, received the money, was to receive some economic benefit, or the person who has been deprived of the money has been deprived of some economic benefit. So in short, that is really one of the first things which a commercial court must consider at the time of entertaining a matter. What is a commercial dispute? Second, the commercial court, which I mentioned right at the beginning, and the Commercial Courts Act is all about fast tracking of procedure. If you compare the provisions with the Civil Procedure Code, then you will find that at each stage, whether it is not whether, from the time of filing of pleadings to the admission and denial of documents, to the taking of evidence, before that production of documents, to the opportunity of delivering a summary judgment, to the adjudication process, including the stage, where affidavits may be filed, whether the court can control evidence, everything is concerned with speed of adjudication, culminating in what is, I would say, the most remarkable feature of the Commercial Courts Act is Order 15A, which is case summary, case management hearing, which empowers a court, with the assistance and the cooperation of the parties and the counsel before it, to fix timelines for every stage of the proceeding. And for that also, it's not that, for example, a judge can, who is in the commercial court, hears a matter or entertains a matter for the first time, and then, just kind of forgets about it and does not take note of Order 15A. There is a specific timeline from which the case management hearing, that whole process has to start. I will come to all that when I start showing the slides. You will get a much better idea of the timelines which the Commercial Courts Act contemplates. So that is really the most remarkable feature of the Commercial Courts Act. And apart from the case management hearing, if you look at every stage, for example, Section 14, that provides for expeditious disposal of appeals. And I must tell you that at the time of when the Act was enacted and it was brought into effect from 23rd of October 2015, the appeal court was given 6 months. That is Section 14, which provides for the commercial appellate court shall endeavor to dispose of appeals filed before it within a period of 6 months from the date of filing of such appeal. But mind you, the legislature did not rest there. It probably, in its wisdom, realized that 6 months is too long a time for the appeal court to decide an appeal. So what it did was, in the 2018 amendment, and I shall mention it in the course of my talk, the 2018 amendment brought in Order 20, or rather the amended Order 20 to the CPC, and said that it is actually 90 days. So 6 months was made 90 days, before which not only the appellate court, but all commercial courts will have to dispose of matters within 90 days. So that is quite something, by way of honoring the vision of the framers. In this context, I should also say that there have been quite a few decisions of the Supreme Court as well as our court also. There was a decision of a learned single judge of this court in Lakshmi Polyfab, which took into account that, once a matter is filed in the commercial division, it cannot really be transferred somewhere else, subject to the fact that the court comes to a conclusion that it is not to do with a commercial dispute. And then the only way possible is a procedure under Order 7, Rule 11, which is rejection of a plaint, dismissal of a suit. That is one decision. There is a decision, the other one is Millennium Steel India versus Reckitt Benckiser, where it says that a suit or an application relating to a commercial dispute of a specified value filed before the original side of a court shall be heard and disposed of only by the commercial division. So it is not that you have a choice, that a commercial division for whatever reason doesn't want to hear the matter. No, you just have to hear the matter unless you goes before some other court. And it also holds that a resolution of a commercial dispute does not stop with the passing of a decree, but must extend to enable the decree holder to enjoy the fruits of the litigation. So that's a very purposive construction, I would say, of the Act, because it is not only about how the process of adjudication goes, but it is also about ensuring that the decree holder who actually wins that adjudication gets the opportunity to enjoy the result. So, the entire execution proceeding also has to have that speed, and there is no slackening of that speed at any point of time. With regard to some of the more salient features, we have Order 8, Rule 1, which all of you, I'm sure, are already familiar with. The CPC, as it stood before amendment, Order 8, Rule 1, it was 90 days. The Calcutta High Court amendment has 2 more relaxing or periods of relaxation. I think the first one, if I remember correctly, was unforeseen circumstances, that a defendant who through unforeseen circumstances is not able to file, then an additional window is given. And the second part of that amendment was reasons beyond his control, that for reasons beyond his control, he will get an additional window for filing the written statement, and all to be calculated from the date of service of the summons. Whereas the Commercial Courts Act, as amended, the CPC as amended by the Commercial Courts Act 8.1, provides a final window of 120 days. We have the the decision on this subject of the Supreme Court. I think it was Justice Nariman in SCG contracts versus Chamankar. That's 2019, pronounced sometime in 2019, where the Supreme Court actually says, and that is now part of the amended Order 8 Rule 1, is that if you can't do it, if a defendant can't file the written statement within the final window of 120 days, then the right to file is forfeited. So very strong, there is no relaxation in that part of the provision. You also have a Delhi High Court decision in Burger King, where the court held that documents such as email, correspondence, etc., should be, everything should be given a very kind of should be given a view in consonance, or which sits in consonance with the object of the Commercial Courts Act, and the time at every level should be cut short. We next come to the other part, which is important, is a 2018 amendment to the Commercial Courts Act, which brought in most important for the legal fraternity, is that it brought down the valuation from 1 crore to 3 lakhs. And that's one. That is the most important one. And the second is, as I mentioned earlier, Order 20. The time frame was finally 90 days. I will just quickly read Order 20 so that I myself can, I don't want to say something which is not correct. It is, yes, that was brought in 2018, and it says the commercial court, commercial appellate court, commercial division or commercial appellate division, as the case may be, shall within 90 days of the conclusion of arguments pronounce judgment, and copies of the judgment shall be issued to all the parties. So that is the other important feature of the 2018 amendment. And 2018 amendment also brought in the other aspect, which is relevant for Calcutta High Court and Bombay and Madras, is that except the territories where the high courts have ordinary original civil jurisdiction, the state government can actually indicate after consulting with the High Court as to how many commercial appellate courts can be formed in a district. So it recognizes the exclusivity of high courts having an ordinary original civil jurisdiction like the Calcutta High Court. So this is the 2018 amendment. And before I go to the important part, which is the amendments to the CPC, I will quickly deal with some of the other important aspects of the Commercial Courts Act, which is Section 12A, which is pre-institution mediation and settlement. Now, this is a totally new idea which came into the, I would say, Indian legislation. And 12A, as all of you must be knowing, all the lawyers and the others of the legal community, that when you present a plaint, apart from all the other letters patent leaves, you also now have to take a leave under Section 12A of the Commercial Courts Act. And that leave is essentially that when you don't have, or when you think that Section 12A is that when you don't have an urgent interim relief to pray for, then you have to first go for mediation. So in a nutshell is that you have to take the court's leave to say that I have an urgent relief to pray for, and therefore I don't want to exhaust the pre-institution mediation at this stage. So I require that leave. This is a very new idea, I would say, and really is in line with this whole thrust of legislation now with the alternative dispute resolution or alternative dispute mechanism redressal system. So arbitrations, mediation, conciliation, these are given a very big impetus to first reduce the load of the courts, and under this act, reduce the load of commercial matters in a commercial court. And more importantly, everyone is aware of the huge pendency of matters. So this, I think, is a step in the right direction, because a court can fringe or can kind of trim matters which should first go for mediation and then come to court. So if you don't need an urgent relief, don't come to the court for interim relief. Don't come to the court without first exhausting mediation. That is an important part. And quickly, there is Dhanbad Fuels versus Union of India decision of the Calcutta High Court, which is 2021 SCC Online 429. And where the Calcutta High Court said that a learned single judge of the Calcutta High Court said that a party should first explore the possibility of settlement, because the purpose is to reduce the load of case pendency before a commercial court. Then we have a Delhi High Court decision in Bank of Baroda versus Suhail Garments, where also the Delhi High Court, the view of the Delhi High Court was that Section 12A is not a requirement which can be waived, but is a formal requirement under the Act, and you have to take the leave of the court to show that you need that urgent interim relief. Then there is Terai Overseas Private Limited versus Kejriwal Sugar. That's also another Calcutta High Court decision of a learned single judge, where the court held that the argument of the party that there was no chance of settlement is not really relevant to Section 12A, because Section 12A is not about settlement. It is about exploring an alternative dispute mechanism, which is mediation. And I've already mentioned Lakshmi Polyfab. And there is another MK Food Products versus SH Food Products, where it's actually the contra view, where I think this was Bombay High Court, which said that no, leave may not be necessary where a party is really seeking relief which is extremely urgent. So the court 12A cannot be viewed in such a strict fashion. So these are the contra cases. There's also a Ganga Taro Vazirani, which is of the Bombay High Court, which had held a similar view, which is, I would say, is different from the Calcutta High Court view, where the judge first asks for leave. And that is actually now inbuilt in most of the planes, I find. And so that is section 12A. And Sukanya, can we now go to the slides, please, so that I can go straight to the amendments which were brought about by the Commercial Courts Act to the Civil Procedure Code. Can we go to slides, please? Sure. Thank you. So what is a commercial dispute? So this is, yes, Sukanya, can I just tell you to change the slide, and then I think that will be easier. So this is just a ready referencer, a quick summation of whatever I said, and it's for keeps. It's a handout, really. So what is a commercial dispute? Section 2C. I don't want to repeat everything in the slide because that's already on your screen. Listed under section 2.1c. I'm sorry, it should be 2.1c on the slide. 2.1c clauses I to XXII. And so those transactions are listed there. And the next tab is that courts have warned against giving a liberal interpretation, which may have the effect of defeating the act. And I've mentioned Ambalal Sarabhai. Can we go to the next slide, please? Yes. So this is section 15. Section 15 is a very common, I have found a very common point in several of the applications. That's transfer of pending cases, section 15 of the Commercial Courts Act. And this relates to transfer of applications which are already pending in the High Court, and they should be transferred to the Commercial Division, provided it relates to a commercial dispute of a specified value, which we find right in the introduction of the Act and in the definition section, and it includes applications under the Arbitration and Conciliation Act. The important pointer is that all pending suits, that's the second tab, all pending suits and applications relating to a commercial dispute shall be transferred to a Commercial Division. And the provisions shall apply to the procedures that were not complete at the time of transfer of such suit. And no transfer of a suit filed in the Commercial Division is to be transferred to any other court. And the last tab is that a suit transferred under section 15 has to be considered as the continuation of the old suit. Can we go to the next slide, please? So this is really a quick margin-wise statement of the amendments brought to the CPC. First is Order 5, Rule 1I, in relation to written statements, and you should read the first and the third together because that is really kind of the crux of the matter. And that's Order 8, which I mentioned, Order 8, Rule 1. So everything is, before it was 30 to 90 days, now final window, 120 days. Order 7, Rule 2, before it was, in cases of recovery of money, you can just state the amount of interest which you claim. Now, after insertion of Rule 2A, after the Commercial Courts Act, the plaintiff has to consider and to contain an extremely clear, precise and specific statement as to what is the amount of interest you want, why do you want it, what are the circumstances. I mean, there's a whole drop-down list under the Act which requires you to do so. Next slide, please. Order 11, a sea change, I would say, in the procedure, an absolute sea change. Before it was just discovery and inspection of the facts of the suit through interrogatories. That was it. There was nothing more provided under Order 11. After the amendment, and practitioners before the court would know how detailed Order 11 has become. In fact, the whole heading has actually changed. It's now become just give me a minute. It's now become disclosure, discovery, and inspection of documents in suits before the commercial division of a high court or a commercial court. This was not there at all in the unamended Order 11, and it provides for parties, it's a mandate on parties to file a list of documents at the stage of filing of plaint, written statement, everything. You have to produce all documents in your power, possession, custody, and control. Those are the 4 exact words used in the section: power, possession, custody, and control. Within a specific window, if there's an urgency for you to produce more documents, you can do so. But then again, within a specific window, and you have to there has to be a declaration on oath that you don't have any more documents under your PPCC. I would for me to remember: power, possession, custody, and control. And I don't want to get to the labyrinth of the provisions of under Order 11, but they are really, really detailed, very confusing also at times. Next, Order 13A, which is summary judgments. Again, a completely new provision. We all know that we were more acquainted with Order 37, but now we have Order 13A under the 2015 Act, which provides that a summary judgment can be given by a court without recording oral evidence. And when a court feels, I will give you the exact language. If the court feels that the plaintiff has no real prospect of succeeding on the claim, defendant has no real prospect of successfully defending the claim, as the case may be, and it can be given without oral evidence, which is a huge thing, I would say. I mean, without evidence, you can actually deliver summary judgment. And but of course, Order 13A rule provides that a defendant, before you give a summary judgment, a defendant must be given at least 30 days notice. So you can't really do that in the absence of the defendant getting to know of the matter. And Order 15A, I've already touched upon, that is case management hearings. And what is important is, as I mentioned, there's a timeline for that also, because it says Order 15A1 that the first case management hearing shall be held by the court not later than 4 weeks from the date of filing of affidavit of admission and denial of documents. So that is, as you know, admission of denial of documents is under Order 11 Rule 4 of the of the CPC as amended. And so that is also a specific time frame. So a court cannot really sit back and relax and let the proceedings begin and continue, but it is under that obligation to do so. And Order 15A is really unique because at every stage, not only the first case management hearing, but if you see Order 15A Rule 3, there is a time for completion of trial. If you see under Rule 4, there is a time for recording of oral evidence on a day-to-day basis. So it is not that, it can be done whenever the court wants, on a day-to-day basis. There is a time for the entire adjudication process during trial. And after the case management hearing, during, what is the court empowered to do? All that is part of Order 15A. Sukanya, next slide, please. Next, quickly, I have about 10 minutes left. Order 18, Rule 2, which is written arguments. So that is also really undergone quite a bit of change, because before, if you see the screen, what it was, and after, now written arguments, there's a form, there's a streamlining of the way pleadings are to be filed under distinct headings and within a certain time frame. As soon as oral arguments are over, you file. And the change which I have seen is, normally what we do and still do is that once oral arguments are concluded, we usually ask for notes. But under the Commercial Courts Act, just to aid and speed up the process, you can actually ask for notes, and that's Order 18 Rule 2. You can ask for the notes as soon as oral arguments are over, or even during the proceedings, so that you can, while parties are arguing, you can actually look at the notes, refer to them, ask questions, and you, as the judge of the commercial courts, you yourself get prepared in the process. And I personally, that's a huge help. It's a huge help to me. Next, Order 19, which is procedure related to affidavits. There was, in the unamended provisions of the CPC, there was no such provision. But now, as I mentioned sometime earlier, a court can actually control. A court has a power to control evidence. It can delete evidence. It can redact. Redact is another word for edit. It can edit evidence. It can. The court has discretion to exclude and reject affidavits, which, if the court finds that they would actually delay the proceedings. Just wanted to, because I'm so interested in the proceedings and they're still so new to me, Order 19 as amended also gives format and guidelines for filing affidavit of evidence. That's Order 19 Rule 6 A, B, C, D, which actually the parties must comply with. And if you have any, if you have any material, then you should say where you've got that from, what is the source. If you want to rely on any separate document, that has a mechanism for filing the pleading. Everything is provided for. And lastly, Order 20, Rule 1, which is, as I said, it's now that all courts, all commercial courts, commercial court, commercial division, appellate division, its maximum time is 90 days from the date of conclusion of hearings. And mind you, there's a Section 17 of the Commercial Courts Act. Is it Section 17? Just give me a moment, please. Yes, Section 17 of the Commercial Courts Act, where commercial courts, commercial division, etc., commercial appellate division, they are under an obligation now to disclose by way of data the pendency, disposal, everything. So, you're constantly under this monitoring that whether you're doing your work or not. So there's a huge pressure, but I would say it's a good pressure in keeping with the object of the Act. So Kanya, next slide, please. Yes, a quick graphic and a pretty representation of speedy resolution of disputes. So if the suit does not arise out of a commercial dispute, rigors of the 2015 Act would not apply. That is Lady Moon Towers. The hexagonal box gives you the case, the name of the case. Then substantive rights would have precedence. That was a judgment under Order 13, under summary, was it summary judgment, where it was held that substantive rights would still have precedence. So if there's a window given to a party, then whether that statement of truth is a mandatory requirement or not, the court will have the leeway to decide. And statement of truth, which I think is provided under, I'll quickly give you, because I was also, yes, it's Appendix 1 to the first schedule, and that's under Order 6, Rule 15A, and Order 11, Rule 3. It's Appendix 1, Statement of Truth, whether it's mandatory or directory. Then you have expediency and speed to be practiced, not only till the decree, but till the fruits are reaped, that is bare intellectual property. Then you have filing of written statement. I've mentioned it, SGC contracts. You have the admission of denial. You have the process of admission and denial, where that it is to be cut short, that is Burger King. And you have that late filing of documents cannot be allowed unless good cause is shown and established. That's Nitin Gupta versus Texmeco. Next slide, please. Yes, Section 12A, pre-institution mediation and settlement. The parties must first exhaust the remedy of pre-institution mediation. That is Dhanbad Fuels and Terai Overseas. I've already mentioned that. Next slide, please. I think, is this the last slide, Sukanya? Yes, this is the last slide. So, second last slide, yes. So this is the statistics. And when I come to this slide, I come to the last part of my talk this evening. That is whether the Act has been successful in its objectives. And for that, I just have to show you statistics. India's ranking, the country's ranking, India's ranking under the Ease of Doing Business Index of the World Bank, among 190 countries in the last 5 years. In 2017, if you remember, that is the time when the Commercial Courts Act came in Calcutta High Court. The commercial division and the commercial appellate division was set up in 2017. That point of time, India was 130, 100, 77, 63, 2021, 63. So not much change in the last 1 year, but pandemic and everything else. It is, I don't know whether it's a remarkable movement upwards, but at least a movement. So some sort of a ready reference as to whether the Commercial Courts Act has made some change or not. The last slide, please. Yes, success and growth. So we have success on the left, and I didn't want to say failures. Critiques is a better word. And I really have to thank my law clerk, Shivangi, for putting this across, for getting this together. So more than 10,000 disputes settled in Delhi, Bombay, Calcutta, and Bangalore. The slide mentions the cities. I'm mentioning the high courts. Then before, it used to take 1095 days in the trial and judgment of commercial matters. Now it takes 306 to 424 days for final resolution. Then a jump from 142 to 63 in the World Bank Index, and quite a few commercial courts in Delhi, Maharashtra, 22 in Delhi, 16 in Maharashtra, 9 in Karnataka, 8 in Bangalore. As of now, we have 3 in Calcutta High Court. That's not the commercial courts. That's excluding the commercial courts. I'm only talking about the commercial division and the commercial appellate division. And now for the critiques. Pendency, you all are aware. 2,900. The comma should have probably come after 2 pending cases in all the 4 major cities. Then despite the Commercial Courts Act and the push for speedy resolution of disputes, fast tracking, everything, there is still the problem, the eternal problem of the country's inability to enforce contracts and resolve disputes as, in a really time-bound fashion. Then commercial courts can't function as specialized courts because of an ongoing, ongoing problem with regard to strength of the bench, number of judges. Then lack of infrastructure in the states. That is also a point of concern because after all, we all need money for infrastructure. Commercial courts are heavily dependent on infrastructure. So that is one of the critiques. So I think this is the last slide. Thank you, Sukanya. And if I can just come back to the screen for my last thoughts, for which I shall take 1 minute. So despite this emphasis on the Commercial Courts Act, and I have personally a lot of interest in commercial courts, on how to regulate commercial courts, how to decide matters in the commercial courts, as I'm sure a lot of my colleagues also do, not only in the Calcutta High Court, but also across the country. But having said that, the Commercial Courts Act really has resulted in, or has put legislative seal on creating a subclass of courts and matters. As you know, commercial matters are supposed to be the first in the list. Most courts publish a separate list for commercial matters. So this precedence, I think sometimes, well, it is good for the objective of the Act. I'm not sure how good it is when we see the pressure of matters in a court, the pressure of constitutional matters, the pressure of revenue matters. Why constitutional revenue matters? Ordinary suits, matters which are non-commercial in nature, huge number of matters. So practically, it is a very delicate balancing task which a court must do, to give precedence to commercial matters, but at the same time, give enough time to non-commercial matters, so that, you know, other matters are not ignored. That's number one. Number two, Section 20 of the Commercial Courts Act provides for training of judges in the commercial courts who take commercial matters. And it's not only training, but it provides for continuous training. So it's not that, you know, I receive a one-time training and I start taking matters. I have to be continuously trained. So that is something, and the state government also has a role in it. That's under Section 20. That is something which we need to put some thought on, because after all, if it is fast tracking, it also requires a bit of familiarity and training of the judge who takes these matters, so that, it's not always learning on the job. You know exactly, as soon as a matter comes, you know what the point is, which way the matter should go, how to fix timings, how much time to give to counsel. So that is, I think, very important, but not much thought really is given to this, probably because of lack of infrastructure, lack of funds, lack of resources. The other thing which I think is that the amendments to the CPC now under Section 16 of the Commercial Courts Act, 16.3 in particular, you don't have the option anymore of going back to the unamended provisions of CPC subject to Section 15. You have to bring in the rigors and the timelines of the Commercial Courts Act. The last thought I had is that commercial courts are dependent on the level of commerce in the state. So if the level of commerce is vibrant, it's kind of healthy, robust, then that would have a sure and a certain reflection on commercial courts. So in that way, I am speaking to an appropriate target audience. And as I said, you are the feeder as well as the assessor of how the commercial courts are functioning. And we would be very happy, and we would receive all comments about the way of the function of the courts, as and when you feel fit to share the same with us. And I would just end by saying that for Calcutta High Court at least, Commercial Courts Act, I see it as a newfangled addition to the original side jurisdiction as it was through all these years. It's now just being given a more specific, a more a glamorous kind of an avatar, but it was always there. Calcutta High Court always had it. The kind of matters which were filed in the original side. It's just now that it has a stamp of a new statute. So thank you very much. I really enjoyed speaking to all of you. I enjoyed going through the cases and the provisions, which we don't really get much time to do all the while we are looking at other matters as well. Thank you very much. It's been a great evening. Thank you.
Thank you so much, my lord. Before we conclude the session, we would request the co-chairperson of the Legal Committee of the Bengal Chamber, Mr. Prashanto Kumar Dotto, to give a formal vote of thanks.
Good evening. My Lord, the Honorable Justice Moushumi Bhattacharya, my colleagues from Legal Committee of the Chamber, the valued delegates. It's my privilege to propose a formal vote of thanks on behalf of the Chamber. I extend my sincere gratitude to Honorable Justice Moushumi Bhattacharya for taking out time from her busy schedule to grace the occasion. Today in the platform, we heard about the Commercial Courts Act 2015 and also how far it has been successful. It was a detailed discussion. My Lord, we thank you for your deliberation, which has indeed enriched us on the subject. We thank for the support rendered by all concerned in organizing the program. We thank the participants who attended the program through various digital platforms of BCCI. Thank you all. Stay safe. Have a wonderful weekend.
Thank you.
Thank you so much, sir. Before we finally conclude our today's wonderful session, on behalf of the Bengal Chamber, we would like to thank our partners of this entire session, Victor Moses and Company and Sanderson and Morgans, who have come forward and helped us in organizing this fantastic session. Thank you so much for joining us. We thank all our participants and all who attended through our digital platforms. Thank you so much and good night. Stay safe.
Thank you.
Recording stopped.